By way of opening remarks, let me say, as we all know, the question of human rights vis-a-vis the question of legislating or having a legal framework on terrorism and anti-money laundering projects a lot of conflicting or competing interests. We have the interest of the wider public on one side, the interest of the globe on one side, vis-a-vis the interest of the rights of the individual. So, and in many occasions, people tend to protect the rights of individuals because there are instruments, both international and domestic, which protects those rights. So it is a question of trying to jungle or to balance those competing interests. That is what I'll try to do as I demonstrate to you those conflicting interests. I'll start by a quotation from a report by the House of Lords of the European Union Committee on 19th report, that is session 2008-2009, where the report provided that, acquisition of wealth and property of others is the ultimate objective of every criminal. Those assets are also the lubricant of criminal activity and so the motivation for further crime. In the case of the terrorist, finance is acquired not as an end in itself, but to achieve political ends by violent means. This more or less covers the topic itself. It shows you what criminals aspire to do, and then it brings you back to the question of the end result of a terrorist. Then there is a definition which we could get on money laundering. This is a process by which the source and ownership of criminally deprived wealth and property is changed to confer on it a perception of legitimacy. Then there are stages. Many scholars talk about 3 stages, but I think when I looked through, I added the first one, which is first is the acquisition of the funds through unlawful means, because the funds must be acquired first through unlawful means. Then now there is an intention to conceal or disguise the sources of the funds. Then the third is that the funds from the criminal activity are either placed in a financial institution or used to purchase assets. And the very last, the funds are now integrated into legitimate economic and financial systems. Terrorism financing. This is a criminal activity we all know, both at domestic and international level. Then, of course, terrorist groups or terrorists must develop sources of funding, a means of laundering those funds, and a way of purchasing tools of trade. That is the tools, I'm using the word tools of trade, not in a normal way, but to mean that those items which are used to undertake the terrorist activities. As a result of that, I think the world all over, beginning with the UN, has taken steps towards combating terrorism financing. These programs and strategies are geared towards preventing, tracing, and recovering illicit acquired assets that are the proceeds of more than 300 predicate crimes, and to disrupt and dismantle global terrorist financial and criminal laundering operations. Now, while the world is doing that, it has recognized that there is need to respect internationally recognized human rights norms. Now, I've tried to summarize the international instruments relating to anti-money laundering and counterterrorism. And when you look at those ones without going to specific ones, you will start with the UN International Convention for the Suppression of the Financing of Terrorism, 1999. Then we have the UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, 1988. We have the Convention on Laundering, Search, Seizure, and Confiscation of Proceeds of Crime and on the Financing of Terrorism. We have the UN Convention Against International Organized Crime, UN Convention Against Corruption. Then we have, of course, the UN Security Council resolutions. There is debate as to whether they are international instruments or not, but those resolutions form part of what is international law. Then we have the European Union instruments and conventions. There are various of those which relate to anti-money laundering and counterterrorism legal framework. Then we have another group called Egmont Group, and I think most of you know about this group. Though it's an informal group, but it's very active because it involves financial intelligence units. Then, of course, you have heard what the speakers mentioned about the Financial Action Task Force. This is not an instrument as such, but is a body for intergovernmental body for development and promotion of national and international policies to combat money laundering and terrorism financing. Then I go down to domestic, that is in Kenya. In Kenya, of course, we have now the Constitution of Kenya, which recognizes international conventions and instruments by virtue of Article 2(6) of the Constitution. Then again, if you go to Article 40, you will see a provision where if you have acquired property unlawfully, you are not protected under Article 40, which talks about the right to property. Then the main instrument which regulates the anti-money laundering is Proceeds of Crime and I think I've left, it's supposed to be Proceeds of Crime and Anti-Money Laundering Act 2009. I'll come back to this act and demonstrate some of the clauses which we think they conflict with the Constitution and international instruments. Then, of course, we have the Penal Code, we have the Criminal Procedure Code, we have the Protection of Aircrafts Act, then we have the Civil Procedure Code, I've analyzed down there, then we have the Official Secrets Act, we have the Evidence Act, we have the Firearms Act, we have, of course, the Banking Act, which majority of you are familiar with. We have the Narcotic Drugs and Psychotropic, not psychological, Psychotropic Substances Control Act. Then we have Extradition Act, we have Extradition Commonwealth Act, then Fugitive Offenders Pursuit Act. We have the now proposed Prevention of Terrorism Bill, which I believe is now at the committee stage in Parliament. The human rights issues which are related to anti-money laundering and counter-terrorism. Of course, this is a main area of the right to a fair trial because of the emotions involved in these terrorism activities. You remember, I think last week when there was a terrorist activity in Isili, in Nairobi, when you gauge the public mood then, one would automatically feel that there is a proposition or there's an imagination that if you are able to arrest a terrorist, you do not have to put him through the stages of due process of the law. You do not have to put him through the stages of going to a court of law, evidence adduced, then you are convicted. That is the emotion which is involved when it comes to terrorists. That is how the public would want to deal with them. But since we all say that the due process, the rule of law, must be respected, and unless we have the rule of law and due process, then we must be patient and go through those stages. And if you rush some of those stages without following the procedure, then you are in conflict with what we call a fair trial. I'll come later to what is there in our constitution in terms of fair trial. Then we have the right not to be subjected to arbitrary detention. We know there's always this international debate about terrorists, suspected persons who are probably not terrorists, but suspected to be terrorists, being arrested in the Arabic world, especially by the Western world, and detained in places including Guantanamo Bay. And you remember the debate goes on and says that indeed, as a result of some of these atrocities involving terrorists or involving persons who have been suspected to be terrorists, the killings of persons in pursuit of these terrorists may amount to international crimes. And there's a big debate about whether or not President Bush and Tony Blair would not be in the ICC facing trial because of some attacks. Those are debates going on. That is why we talk about the right not to be subjected to arbitrary detention. That is a right which is recognized both domestic and international. And that there is that debate which has been going on. Freedom from torture. You know, sometimes when you're trying to extract information, we have seen it in real life and probably sometimes in movies. When you are trying to extract information from a suspect who is suspected to be a terrorist, sometimes extrajudicial means are applied, including torture and treating them in an inhuman manner. This is a right which is protected internationally. Then we have the right to freedom of expression, that you cannot, you have a right to say what you want to say, freedom of the conscience, but sometimes it's suppressed by what you can say by some of this legislation involving terrorists. Then freedom of movement, of course, the right to privacy. If you look at especially the proceeds of crime, and I'll come to that later, the proceeds of crime and anti-money laundering bill, I think section 40, I think 44, 44. If you look at section 44, it says that the center, that is Kitili's officers and police officers who are probably assigned in the center, they can move into your house if it is necessary without a search warrant and confiscate documents and search your house without a warrant. Those are things which will come to later in terms of the right to privacy. Then we have right to non-discrimination. Why is it that this group, which is said to be terrorist organization or terrorists, they are treated in a different manner by the law than the rest of the community? Those are issues which have been interrogated. They are still subject of debate as to whether these laws are discriminatory or not. Then we have the right to an effective remedy for a breach of human rights. Sometimes, and I'll demonstrate in one of the cases called the Kadi case later on, where the resolutions of UN resolutions or committee on blacklisting, let me use that word, would say that if you're suspected as a group, you'd be blacklisted, and probably you have no remedy to go and defend yourself. But those regulations have not been amended as a result of that rule, that case, sorry. Then, as you can see, these and other fundamental human rights are protected under international treaties that Kenya has committed to uphold, including the International Covenant on Civil and Political Rights and the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment of Punishment. These rights are also protected under the Bill of Rights in the Constitution. Then, of course, I've highlighted some of the international instruments or steps which have been taken to protect human rights as we fight money laundering and financing of terrorists. You can see that the Security Council resolution that states must ensure that any measures taken to combat terrorism comply with all the obligations under international law and should adopt such measures in accordance with international law and in particular human rights, refugee and humanitarian law. That is Resolution 1456, 15, you can see 1535 all the way. Again, the United Nations Counterterrorism Committee on Human Rights Policy Guidelines, you can see again, have highlighted obligations under international law, including international human rights law, refugee law, and humanitarian law. I'm just trying to highlight the move by the world to protect human rights as we fight terrorism and money laundering. Again, Security Council presidential statement, you can see that the Security Council underlines the need to address the conditions conducive to the spread of terrorism, including but not limited to the need to strengthen efforts for the prevention and resolve prolonged conflicts. and the need to promote the rule of law, the protection of human rights and fundamental freedoms, good governance, tolerance, and inclusiveness to offer a viable alternative to those who could be susceptible to terrorist recruitment and to radicalization leading to violence. The Council further recognized the development, peace, and security, and human rights are interlinked and mutually reinforcing. Again, UN General Assembly Global Counterterrorism Strategy 2006, you can see they're just emphasizing on the human rights. Although this is at the global level, I would want to take more time on the domestic front. But this is just to demonstrate that the recognition of human rights is not just domestic, but it is global. We are, I think, aware of the Counterterrorism Committee Executive Directorate and the Counterterrorism Committee itself. You can see what it does in terms of human rights. Security Council Resolution 1373 has been cited before. You can see relevant human rights issues include ensuring that laws are not vague or overbroad. I'll come to this where you are supposed to ensure that laws are not vague or overbroad. I'll show you in the interpretation section of the Proceeds of Crime and Anti-Money Laundering Act, the one we are using, the way sometimes Parliament has broadened or has used very vague words which can be challenged at that international fora. That is due process, protections in freezing, due process of the law, of course, in protections in freezing of assets must be taken into account. Human rights safeguards in special criminal procedures and in bringing terrorists to justice. Then effective safeguards against devolvement, this is italic, is a principle of international law which forbids the rendering a true victim of persecution to their persecutor, that is to their country. Then effective protection of refugee rights. As I had said, at the international plane, this is one of the cases that is called the Kadi case, involving Yassin Abdullahi Kadi and Council and Commission. This was before the European Court of Justice, where there's a UN Security Council called UN Sanctions Committee, which kind of blacklists persons or organizations which are associated with either Osama bin Laden, Al-Qaeda, or Taliban. And in this case, this person called Yassin Abdullah Kandi and an organization, his organization were blacklisted. And then when he took the case to the European Court of Justice, he alleged that under community law or domestic law, I'm supposed to be protected in terms of being given the right to defend myself, being given the right to appear or to go on for judicial review. And after the court interrogated all the facts, it held that actually they had the right to review UN Security Council resolutions to protect the rights of Mr. Kadi. However, subsequently, what happened in the case is that was reviewed, he was given an opportunity, but later on, they went to the Security Council and he was blacklisted after being given due process. But as a result of this case, the regulations were amended such that one now has an opportunity to go through the due process at that committee stage. I'll come to this case later. This is a domestic case involving an issue which I'll indicate later on. This is just additional, because of time I said there's no time, but I have my paper with me which is available. These are just additional relevant issues. Then you have the benefits of a human rights-based approach. Why should you have a human rights-based approach in combating terrorism in terms of legislation? They are there, you'll be able to read them. Then we have those committee policy guidelines, relevant considerations, all that. I'm not going to talk about that now. I'll go straight to, I'll go straight to Proceeds of Crime and Anti-Money Laundering Act vis-a-vis the Bill of Rights. As I said initially, there's a need to harmonize the act with the Bill of Rights in the Constitution. Otherwise, if that does not happen, you remember one of the provisions in the Constitution is that if you want to limit the rights of individuals or citizens which have been provided for under the Bill of Rights through a legislation or an act of parliament, then you are required to comply with the Constitution by saying, one, we want to limit the right to freedom of expression, the right to privacy, and as a result of limiting that right, the reasons for doing it, these are the reasons. That needs to be done under the Act. So in my opinion, unless that happens to harmonize this, I know there was an amendment which actually I think went through Parliament, but I looked at those amendments, they didn't take into consideration what is provided in the Constitution, that when you are limiting rights, you need to specifically state so in the Act, and you need to give reasons for that. That is wanting in the amendments which went through Parliament. And the challenge here is that if we have to fight money laundering and financing of terrorist activities through this Act of Parliament, chances are that one would raise those constitutional issues, and as a result, we may have suspects who have actually committed terrorism, or organizations which fund terrorism getting away with it because of that constitutional aspect. Then the conflicts, Section 2, interpretation. They first say that once you have been charged, that is interpretation of Section 2 on defendant, once you have been charged in court of law, whether or not you have been convicted with an offense, then it doesn't matter, you will be treated as if you are a criminal or that you have been convicted. That is the interpretation which one would read, because now your properties can be confiscated, your relatives' properties can be confiscated, you can have your property searched. The treatment itself, it doesn't accord with Article 50 in relation to fair hearing. I'll come to this issue of fair hearing through that case which I've demonstrated. Section 3, this is an example. I didn't say that Grand Regency is, that is an example. I said in event there has been a debate as to whether the money which funded or built the Grand Regency, which is now Lyco Regency, whether the money which was used came from the Golden Bag scandal. There's that debate which has been going on. And what Section 3 talks about is dealing with the property. Anyone who has dealt with the property in any manner, if it is established that this property has been acquired through money laundering, then that person is guilty. What it means, this is a far-fetched example, but what it means is that even the person who painted the word, who removed the word Grand Regency and put Lyco Regency can fall under this bracket. I want to demonstrate why sometimes the international community has said that you have to be very specific when you are dealing with these issues. You cannot be as broad as you want. Then Section 24, of course, which gives, I've spoken about it, which gives police officers and inspectors from the center the powers to go to a bank, then investigate an issue and get copies of those documents without a search warrant. What that means is that it definitely conflicts with Article 25. That needs to be balanced, that you cannot have entities invading private property or private business. And I know you may say that we are fighting terrorism, we are fighting money laundering, but you cannot have entities or an agency of government invading a banking institution which has obligations under the Banking Act, which has obligation under the Constitution to safeguard the interests of its customers, and taking copies of these documents without being cautious about it. That is why we are saying, in our opinion, it conflicts. But this is a debate. It conflicts very clearly with Article 25 on fundamental freedoms. I've indicated Section 44, yes, where if you are reporting institution, you are supposed to report unusual, suspicious, large, and other transactions. For us, it is a good thing. However, this reporting where you have not described what these unusual, suspicious, large transactions are, Article 19, still under the rights and fundamental freedoms, is clearly saying that you cannot do that. Again, as I said, you try to limit, in that act, Section 44, try to limit some rights and fundamental freedoms in the Constitution. But there is no indication in the act that there's an intention of Parliament to do that. Unless that indication is there, then we will fall back to Article 24, that those rights have been limited, yet there has not been a provision in the Act of Parliament. We have also indicated Article 27, equality and freedom from discrimination. Why would you pick on XY in a bank and not A and B? Those are issues to be raised. And I'll show you the dangers of leaving it hanging through the case I'm going to, Crimes Act. The officers can move in and tell you, we want to audit your lifestyle. Why are you living in this kind of lifestyle, yet your salary is 10,000 shillings? Tell us where you obtained this money to construct this house. Tell us where you obtained this money to drive this kind of car. Again, there's a decision which I'm sharing with you where this conflicts with Article 25, definitely, Article 27 and Article 47. What is required is just to make sure that this kind of legislation is insulated from attack in terms of the constitutional provisions. Then there is Section 69, of course, about restraint of trade. Then before I come to the conclusion, I want to share with you this case which I've mentioned, which this is a Stanley Mambo Amuti versus the Kenya Anti-Corruption Commission. What happened in this case is that, I think you remember this was the MD of Water Conservation and Pipeline Corporation at that time. That is in 2008. And there was suspicion that he is a conduit for corruption money through ministers and other officials. And when the anti-corruption officers got that information, they invaded his house without a warrant of arrest. After invading the house, they found in his house a lot of title deeds, about 16 title deeds, which were in his name. They found Kenya shillings 4 million in cash, and they confiscated bank account documents and other documents. Then they went to court and said, under the Anti-Corruption and Economic Crimes Act, we are entitled now to confiscate this property and convert it to government money, and on top of that, we seek 140 million being the deposits from his account. It showed that he had deposited 140 million, although it was not there, but it could be seen from the statement that this money was being deposited over a period of time, and they sought an order that he pays 140 million. The gentleman went to court and said, you cannot audit, you cannot shift the burden because you are telling me, prove how you got this, prove how you got this title deeds. And then the court, after looking at Section 55 of the Anti-Corruption and Economic Crimes Act, it came to the conclusion that it was in conflict with Article 24 of the Constitution in terms of, first, the burden cannot shift from him. It has to be them to come with evidence, not to ask him to provide the evidence how he acquired that kind of wealth. And secondly, that he must show the Constitution, the word in the Constitution says unlawfully acquired. Unlawfully, they must show the unlawful acquisition. That is what the court came into the conclusion. This matter, of course, the DPP and the Attorney General have appealed against this decision because some people say it is a bad decision. But I'm trying to show you at the moment, because it has not been overturned, that is the position of the law because the court has interpreted this. This can actually being extended to the Proceeds of Crime and Proceeds of Crime and Anti-Money Laundering Act. Sorry, I've taken long, but I had to go through this. That is all about the presentation. If there are any queries, I can see we have, it's 20 past noon. I can take them up. I said that it needed more time, but I've tried as much as possible to chew as much as I can within that short period. Thank you very much. first, at the extreme end, there is no law which prohibits a person who's been convicted of a criminal offense to hold an account, a bank account. That is buttressed by the fact that banks are also in business. I know as much as you also want to protect issues of money laundering, to protect issues of integrity from the bank perspective, issues of anti-terrorism. It is within the sphere of the bank itself, because it's a contract. When somebody opens an account with you, it's a contract. You are free to choose the person you want to open the account with or not. So it is basically the bank's prerogative to, once it has information that so-and-so is a criminal or he has a criminal record, it is basically for the bank to make a determination as to whether they need to hold an account for that person who has a criminal record. But as I've said, I've not seen any law which says that once you have been convicted, you cannot hold an account. It is for the bank now to balance what was this conviction and what our interests as a bank vis-a-vis this conviction record. So basically it's for the bank to make that determination, but legally there's no provision which says that you can't do that. I didn't quite understand when you said chapter 6, what you indicated, but basically chapter 6 is about integrity and leadership. That you must be forthright. You must, as they say, standing like Caesar's wife. That is what they say, that you should not have any doubts. You should be, in terms of morality, in terms of professionalism, you should not have any kind of doubts in your wholesomeness. So that is basically chapter 6. Mostly chapter 6 applies to individuals, not really to institutions, because it's combination of integrity and leadership. Although I know these persons are the ones who lead institutions, but it applies basically on individuals. Thank you.
What I was asking was, recently a court held judgment against a person, known person in the country, relating to that particular chapter. What should I do as a banker? Does that mean that I should not, for example, decide to open an account for this person? Can somebody then say, well...
No, I think by doing that you'll have overstretched it. By doing that you'll have, if I recollect the decision which you have mentioned, I think it relates to the head of the Kenya Anti-Corruption Commission. I've read the decision myself, and I do not want to comment much about it because it has gone to the Court of Appeal again. But you cannot say, based on that decision, which talks about this person is under investigation, so is not fit to head this kind of debate, or there was a question about some document which is signed, or an affidavit which is so, where it appears the facts are different from what is stated. I don't think as a banking institution you can use that and deny that person opening an account in a bank. Chapter 6 on leadership and integrity is of a stretch. It's not a business one. In fact, I know as a matter of fact that if you are to scrutinize businessmen under chapter 6, you will have no accounts in these banks. Because majority of them are unscrupulous. They do not play by the rules, and they can't pass chapter 6. So if you use chapter 6, it's a sure way of telling banks to close business. Thank you.
Okay, we have had a bit of debate on this. Any other issues you would want to raise before?
To that, If you look at 44, what it says 44 is that, 1 minute. Yes. Books of accounts, records, audit, and reports. A reporting institution shall monitor on an ongoing basis all complex, unusual, suspicious, large, or other transactions as may be specified in the regulations, whether completed or not, and shall pay attention to all unusual patterns of transactions, to insignificant but periodic patterns of transactions that have no apparent economic or lawful purpose as stipulated in the regulations. Then 2, upon suspicion that any of the transactions or activities described in subsection 1 or other transaction or activity could constitute or be related to money laundering or the proceeds of crime, a reporting institution shall report the suspicious or unusual transaction or activity to the center in the prescribed form immediately, and in any event within 7 days of the date the transaction or activity that is considered to be suspicious occurred. It goes all the way. What I meant is this: assuming I have an account in X bank and I deposit 10 million shillings, that is an extreme. I deposit 10 million shillings by over check. Then you now unilaterally as a bank make a determination that this is a suspicious or unusual transaction, and you report that to the center. That is what the law provides. You report that to the center. What is my remedy as I've not been given due process by this individual who is doing the reporting first? What would be my remedy as a customer, where I've been reported and this information goes to a third party? Then after the center interrogates it, it is supposed to report to law enforcement agencies. That is what the Act provides. As an individual, I'm saying that as an individual, if I get knowledge of the fact that that is what you have done as a bank, I can have a recourse in law to take you to court, because unilaterally you have no mandate to say that you are in your own way without any evidence or without calling me to explain anything that this is a suspicious transaction. That is what I meant. And you remember the Macharia case against Standard Bank. That is exactly what happened against the Standard Bank. The Standard Bank defroze an account for Macharia, and out of freezing the account, it reported that to the Attorney General. To the Central Bank, to the Central Bank. Then the Attorney General took it up, investigated. Subsequently, it was found that the transaction was not unusual or unlawful. And because of that, you remember it was one of the cases where colossal damages were awarded by the court. Although, again, it is a question of the case is still in the Court of Appeal. They have appealed against it, but damages were awarded. I'm not saying that that is the law, but I'm saying that this is what is in conflict with some of these rights. That is what I was explaining.
I guess I would just comment that obviously the Attorney General and the President signed Cocamelot into law with the expectation law enforcement would be able to look at the very types of serious examples of
domestic. That is the angle which you would take. However, we have the danger of abuse of those powers where you have the center having his investigating officers coming in, probably for other reasons, to say that this is a suspicious account, give me this. Or the bank itself saying that this is a suspicious transaction, give me this. And again, what I would want myself is the other sections where the court is involved. I would rather, because every country is unique in its own way, I would rather we have involvement of the court, that if you want to interrogate this account and there's a suspicious account, we have a unit in the court system where that officer would say, these are the reasons why I think this account needs to be investigated, that this is the reason why we want documents in respect of this. Even at the experted stage, that is, even without calling the other person, just going to a magistrate or going to a judge and say, this is what I have, and this is why I think that this account needs to be say, frozen or documents to be obtained. And then an order is issued by the court. We are avoiding a situation where we are leaving it to the bank, or I'm not myself saying that I'm the one who is avoiding, but the Constitution avoids a situation where you leave it to the bank or to the center itself to make those determinations unilaterally without involving the account holder. That is basically what I'm saying.
And the Twin Towers went down. I think the administration there, we had to push for them. They have revised their law so that we were able to get information, private information, conversations, telephone conversation, tap, and all that. They had to change the law because of prevailing circumstances. In Kenya there, I think we had some arrest in the city, and somebody was found with a lot of weapons and taken to court and jailed for about 59 years. I don't think the police went to get warrants to search or to investigate. That would have leaked, and that person probably would have run away. The other day, we also had some Iranians who had planned a murder of a bomb in Kenya. And I think the police had trailed them for some time. I don't think they got warrants or they got whatever. What I'm trying to say is, people always hide under the cover of the Constitution that we passed in 2010. If the Constitution has got weaknesses, I think that is what we should address. Because when the two Iranians were taken to court, I was shocked that the court even granted them bond. Later, I think it was enhanced and they were either unable to pay, because it would be very uncomfortable for them to be walking in the streets, and they were meant to kill Kenyans. I think the other day we also we saw a Kenyan child who was killed because of a grenade or something. So I think the law is dynamic, and the law should be changed to address the society needs. So we should not always hide under the cover of the Constitution. If it has problems, then let us adjust it to suit the majority. Thank you.
And situations change. You have mentioned about 9/11. Unfortunately, in our case, we changed the law in 2010, August 27th. We adopted a constitution which was very progressive, which is very progressive. And part of what it did, I would say, it didn't take into consideration the issues you are raising now. It emphasized a lot on the individual rights vis-a-vis the public. And there was a reason why the persons who wrote the Constitution, the Committee of Experts and the referendum, had to make emphasis on those rights because of where we had come from in terms of dictatorial regimes. And that is what was being addressed. As a matter of fact, the law then was informed by the fact that there were fears that the government machinery, government agency is used by the executive or by parliament to suppress rights of the individuals. That is why it opened a Bill of Rights, which I think it is the best in Africa. Or even you want to extend, sometimes it is somewhere in a good number in the world. If at that time, this debate about terrorism, about attacks, about the fight in Kismayo, if it was probably the public and the Committee of Experts may have looked at ways of trying to limit some of these rights. However, I want you to take into account this. I want to tell you why the right of you as a person is guarded jealously by the court, irrespective of what we think about in this audience. When the law on rape was amended, courts were very firm in applying that law. And one of the gentlemen who was released last year, because of that, he was sentenced to 9 years imprisonment. It turned up, I think you could have seen the story in the Advocates magazine. It turned out with a confession from the person who said that they were raped, that actually there was no rape, it was a malicious complaint, and she confessed, and it was meant to settle certain scores. And this person, because of the fact that it was applied firmly, and there was a lot of pressure from especially women rights organizations, including FIDA, that person served 9 years in prison. Now, that is one individual. His rights were violated and he served 9 years. That is, I'm trying to show you an example of why it is very critical for that one person to have his rights protected. Because that person can be you. It is not necessarily that this is the fellow who raped or who allegedly raped the person, but this is a right which, or for instance, because we want to deal with terrorism and we want to deal with money laundering, we say that we do not want, there's no search warrant, we just come in and arrest you and charge you. Suppose people want to, or the government wants to settle scores and you're implicated and your documents are planted in your house and you're arrested. And because we are saying that we have to deal with these people family, I've just given you an example. And I'm not saying that I support terrorism. I can't. Nobody would support that. But we have to protect the rights of these people. I can tell you for certain that the person who threw the grenade at Isili when the children were going to nursery school, if by a chance somebody had raised an issue to say, I've seen this fellow is the one who has thrown that grenade, and if this person started running, and by bad luck is of Somali origin, that person would have been killed. There would have been no, am I talking the truth? There would have been no question as about, please let's arrest this person and take him to a court of law, to the police, so that we can find out whether indeed he threw that grenade. That is why they are protected. We do not want that to happen. You remember the issue of mob justice or mob injustice in Kenya some times back, 10 or so years back? How many people died who are innocent? Before people realized, after the media now serialized these issues, very many people died because, in fact, at one point, when you are disagree with somebody, you only need to say Mwizi. At that point, you say Mwizi, and people will start chasing this person. They will stone him, and they will put a tire and ban him. And then people realize, really, sometimes we are banning these people, and some of these people are innocent. That is why we emphasize on due process. I don't know, it's a balance. I agree with you 100%, but it's a balance which must be. That is why we have these courts. And probably what you're saying now, I can tell you one of the reasons why this bill on prevention of terrorism passed through Parliament in that state the way it was is because of the pressure and because of what has been happening in the country in terms of attacks. If these attacks were not there, the Muslim world would have raised issues and it would have been shelved the way it was done in 2005. It would have been just shelved. They're waiting on that. But because of what was happening in the country, there was no much pressure to shelve that bill. And probably, as you say, the passing of the bill was informed by the fact that there has been a lot of attacks in Kenya. That is what I can say just to add on to what you have just pointed out. Thank you very much.